Welcome to video number 3 of Staff Lawyers Claim Your Rights series. My name is Neil Fishman. I am the founder of Staff Lawyer. Today, we're going to discuss what is mediation and what it isn't. What are the causes of conflict in the United Nations and international organization workplace? We're going to also discuss some frequently asked questions about mediation, things that they don't tell you when they ask you if you'd like to be part of a mediation. And finally, I'm going to provide just a few tips about resolving a conflict through mediation. So first, the most important thing is, what is mediation? Well, mediation is a voluntary, confidential process and form of resolving a workplace dispute. It's voluntary because no one can ask you to engage in mediation. You have to decide. It's your decision. It's confidential because the discussions that you have between you and another person are staying between you, the other person, and the mediator. It also involves an independent and impartial, trained person who understands what mediation is. Their job is not to make a decision for you or to tell you or the other person who's right or who's wrong. Their job is to put forth guideposts, ground rules, and to control the process so that you can speak with the other party. The job of the mediator is to help 2 or more people or groups reach a solution, and the solution is supposed to be agreeable and acceptable to everyone in the mediation. So now I'll tell you what mediation is not. Mediation is not a disciplinary process. At the end of the process, we are not determining that you're right and the other person is wrong, or that you're wrong. It's a process in which both parties can come together and reach an understanding and figure out a way to move forward. It's not an HR process. Human resources might be involved in assisting you to engage in mediation, but after that, they should leave the process over to a trained mediator, and they should not be directly involved. Additionally, mediation does not involve a judge or a jury. As I mentioned before, it's not the role of a mediator to decide whose fault it is. Fault isn't really the issue here. It's more about trying to figure out a way to move forward. There's no decision maker, and in contrast to other informal processes that organizations like the United Nations, World Health Organization, World Trade Organization, etc., other processes that they set up to try to solve conflict, if there's no mediator involved, if there's not a neutral, independent third party, if no one is enforcing the ground rules, you can't say that it's actually a mediation. So I'll speak briefly about the causes of conflict in the United Nations International Organization context. And frankly, they're not that much different than any other workplace. One thing that happens is relationships break down. They can break down for a variety of reasons, because of bad or suboptimal management practices, unfair treatment or a perception of unfair treatment, an unclear role or expectations within your team, poor training, or poor communication. Conflict can also be caused by disputes over resources, a perception that your colleagues might be getting more than you, or vice versa, a lack of work that's provided to you in contrast to others that you're aware of, a lack of appropriate duties, a lack of information, and finally, and this is something that happens more frequently in the UN context than in other contexts, a cultural misunderstanding. In the United Nations, almost any individual nation can be represented by an employee, and consequently everyone comes into the organization with their own understanding of what a workplace context might be like. What's the proper way to communicate, which practices are correct and which ones are not correct, and all that can lead to a cultural misunderstanding that can lead to a workplace conflict. Any of you who've been involved in workplace conflicts or have witnessed them can understand the big toll that it places on an organization. It can cause a loss of trust between colleagues, absenteeism. It can impact your health in a negative way. It can diminish your morale. Also, it leads to turnover, people leaving the organization, and unfortunately, lawsuits in which one staff member may decide to file a complaint against another, or may file a complaint or a lawsuit against the organization for mistreatment. So those things are obviously very, very negative impacts for conflict, and they can have a long-term adverse impact on an organization, but also on the career of anyone who is involved in them. And perhaps that's the reason why you're watching this video today. So now I'm going to talk to you about why mediation is unique. When I learned to become a mediator and I was first trained in mediation, I learned that mediation was unlike other informal dispute processes. And I'll tell you why. First, is that mediators do not decide your issue. They are not there to tell you or anyone else what is the right decision. No, they are there to make sure that you have an opportunity to be heard, the other person has an opportunity to be heard, and that it's able to move forward. And if the parties decide that there's no way to move forward, then the mediation ends. So a mediator does not decide your issue, you decide your issue. Some people have asked me, can mediation be involved and useful in a situation in which my boss has so much power over me and I have less power? How can we engage in mediation in such circumstances? Well, actually, mediation is particularly useful in that type of a situation because mediation can resolve a power imbalance because everyone gets equal time to talk. Everyone has to be respectful of the ground rules that are established by the mediator, and everyone has an opportunity to tell the other party what they think in a respectful way. And the mediator's job is there to make sure that everyone is allowed that equal opportunity. So in fact, if there's a power imbalance, mediation can be particularly useful. As I mentioned before, the purpose of mediation is to get people talking. So indeed, even if you're part of a frigid environment with your boss or with another colleague, the mediation is intended to get you talking again. So if you feel that you're completely unwilling to talk to another person, mediation might not be suitable for you. However, what I've found is that in mediation cases, sometimes an individual who is initially unwilling to speak to someone else will soften up over time, and what has been a frozen conflict can then be loosened up. Also, mediation is useful at any time of a dispute. Of course, like always, any informal process is started, is more useful the earlier it started. However, mediation can be entered at any time of the dispute as long as there is a good faith willingness on behalf of both parties to talk. So what are the key components of a mediation? What makes it different than another informal process or an effort to, settle an issue through a grievance or a lawsuit? Well, mediations provide an element of safety. You have a trained person there whose job is to let you speak to another person and to make sure that the communications are respectful, so it's safe. There's an element of control because you're not going to be hoodwinked into agreeing or signing to anything. You have to discuss with the other person, you have time to reflect, and you ultimately decide your outcome along with the other person who's in mediation with you. So if you're not able to maintain and find an outcome that is mutually beneficial, no outcome is reached. So you retain control. It allows for cooperation between someone with whom it's been difficult to cooperate in the past. It's cost efficient because it doesn't lead to prolonged litigation, legal fees, and court fees. It also reduces stress. I would be lying to you if I told you that there's no stress, because it does cause stress. Anytime you have to deal with a difficult issue and get to the core problems that you might face, it's going to be stressful. However, litigation that takes 2 or 3 or 4 years is also stressful. So in that regard, mediation is unique, and it does have some very serious benefits. Some statistics that are important. 99% of organizations that have used mediation said that it helped resolve disputes. However, less than 25% of workplaces seem to use it. That's according to a 2020 UK survey. Finally, I'll end the video by providing you with some mediation tips. These are tips that I make sure that when I'm involved in mediation, I make sure the parties are aware of this so that they can move forward. First of all, when is mediation most suitable? Frankly, it's most suitable for misunderstandings. It's not always suitable for serious misconduct. It's not suitable for criminal behavior, and it's not necessarily suitable for a situation in which one party has acted with bad faith or with maliciousness. However, when a poor behavior or suboptimal behavior has come out of a bad habit or out of an lack of knowledge of a person's shortcomings, mediation can be useful to help someone learn about themselves and learn where they can become better. So as long as there's good faith on behalf of both parties to move forward, mediation can be quite useful. If you're invited to participate in a mediation, you should ask, is there in fact going to be a mediator? Who is going to be the mediator and what are their qualifications? If the person works for human resources and is involved in a human resources capacity, they might not be a mediator. You need to make sure that they're independent and that they're impartial. You also need to make sure that they're trained, so you should ask them what are their qualifications. Staff members sometimes ask me, should a mediator be a lawyer? It's not necessary. What's necessary is that the mediator needs to be trained in understanding the process. They must have assertiveness. They must be able to enforce the ground rules. They must be able to create a fair, safe environment and a fair process. Another piece of advice I give to staff members who might be involved in mediation is that they should have a one-on-one discussion with the mediator before the mediation begins. This is important for you so that you can meet the mediator, but it's also important for the mediator because he or she needs to learn about you. They need to learn about what is the dispute, what are you interested in, what are the core issues, and how do you feel. All those things are extremely important, and if you don't have a one-on-one meeting with the mediator beforehand, you're going to be at a disadvantage. Finally, a last piece of advice is that if you're able to reach an agreement through mediation, congratulations. That is a very, very good achievement. However, not all agreements are equal, so it's important for your agreement to be clear, forward-looking, and deal with the core issues. Sometimes when people get down and they talk, as you know, they may talk for a very long time before actually addressing the core issues that they're facing. So it's important for you to make sure that your mediation addresses the core issues. A last piece of advice is that agreements should be SMART. That means they should be specific, measurable, achievable, reliable, and time-based. Ordinarily in a mediation, the agreements will be written down for the parties to keep a copy of. They won't be shared with HR, but they'll be kept by the parties. And the reason is that then afterwards, if the parties find that one or the other is not complying with the agreement, they can politely remind them that they've agreed to do X, Y, or Z, and that they make sure that they undertake their duties. So, in short, that is a short discussion about what is mediation. I hope that this video was helpful to you. If you like it, please like, subscribe, and comment. And until next time, have a great day. Bye-bye.